as a summary, as a general FYI for all of you. All right, so first thing on the agenda today is the disclosure, the pay transparency provisions that will go into effect on January 1st, 2025. These are amendments to an existing Illinois employment law called the Illinois Equal Pay Act. And what they require is the following. First and foremost, these and I'll refer to them as the pay transparency provisions. These provisions, they only apply to you if you have 15 or more employees. If you do not have 15 or more employees, then the next 4 slides are inapplicable to you. They also only apply to you, and I'll talk about this more, if you choose to create a specific job posting. I've been getting a lot of questions. I think there's a lot of confusion out there from employers that this law now requires us to always create a job posting, and that's not true. Many times employers may not create a job posting. For example, if you know that you're going to create a brand new position and you know that I am the person you want to put in that position, you're not going to post it, right? Because you're not going to interview anybody. You know, I'm going to be in that position. So again, 15 or more employees, if you choose to create a job posting, for any job postings posted on or after 1/1/25, these pay transparency provisions apply. They do not apply, for example, if you're going to do old school and put a help wanted sign outside of your business. They do apply, however, if your posting is a company-wide email that says, hey, everybody, just so you know, we're going to be interviewing and posting for this position. That is a job posting, right? So in that scenario, these pay transparency provisions will apply. So what are you required to include in the job posting should you to make and post a job posting after 1/1/25? So we're required to include pay scale and benefits. And what pay scale means, and I'll talk about that a little more specifically in a minute here, is the wage or salary range that you intend to offer for this position. And benefits, it is defined very broadly. And benefits means any type of bonuses, any type of stock options, or any other incentives that you reasonably expect in good faith to offer for this position. And that's important. It's not, we're not looking at this in a vacuum. We're looking at this very limitedly, not limitedly, but we're looking at it from the lens of for this particular position. For the person who, if they're successful, what do you intend to offer this person, right? Now that could be different, right, for every position, right? And that could depend on, for example, right, somebody who's got 10 years of experience, maybe you offer something that is different than what you offer someone with 1 year of experience, right? So again, you're looking at it from, for this particular position, whatever it is, right? What are you going to offer them? In terms of a wage or salary, that could be $15 an hour to $20 an hour. That could be for salary $40,000 to $60,000 an hour. Where do you get that information from? To the extent you have any internal pay scales, right? You can gather that information from there. What have you offered in the past? What are others who are currently in that equivalent position? What are they making? Now you're not beholden to that, right? You're not beholden to that, because ultimately you may say, listen, yeah, we've got people in the position making 60 grand, but for this position we've only budgeted between 40 and 50. All right, well that's what you put up, right? Because that's what you're going to offer for that position, 40 to 50. Now, to the extent you don't want to include that pay range and the benefits in the actual job posting itself, then what the amendments state are that you can include them. You can include a link in the job posting that says, hey, click on this link. This link will take you to our website. And that link in our website, they will have the benefits that we're offering for this position, right? So, you have a laundry list of the different types of benefits. If you don't want to include them in the actual job posting, that's an option. So you may just have in the job posting the wage or salary range, then a link that says for benefits, click on this link. It's going to take you to our webpage. One thing to note, when you are identifying what the bonuses are, to the extent you offer any type of bonus, very careful. Don't promise anything, right? It may be a discretionary bonus, and you don't want an employee, right, who subsequently leaves to say, hey, whatever happened to that bonus you promised me? And you say, what the hell are you talking? We never promised you a bonus. And they pull out your job posting. And they said, yeah, you did, right? Because you used language in the job posting that led me to believe that I would be getting this bonus, right? Non-discretionary type of bonuses to be determined in the sole discretion of the company, right? Language like that negates any inference that this is a promise. When you're looking at the salary or the pay range, right, you're including the lowest to the highest, right? Again, it's of what you intend to offer.
Next problem is,
right? So that's the 40 to 50. Is that what you intend to offer? The lowest is 40, highest is 50. Now that can change, and if it changes, that's okay, right? Let's say, for example, you interview a candidate, and it's an amazing candidate, and the candidate comes back and says, "Listen, I know your posting says the highest is 50, but I have a job offer for 52." And you say, "Hey, we really want this person." You have to go in and amend the posting? No, right? Ultimately, you can change it on the fly, right? But in the posting, it's what do you in good faith intend to offer for that position. With respect to the benefits, right? In terms of how you're describing that, it's a general description of the benefits. We don't need to provide specific details, terms and condition, or dollar value. So, PTO, right? Paid time off, health insurance, vision insurance, dental insurance, right? General type of very descriptive categories like that. You don't need to go in there unless you want to, that says we offer, 2 weeks of PTO that you're going to be eligible for after 90 days of employment. You don't need to do that. You can just say pay time off. Now, just to reiterate again, nothing in this law requires you to actually make a job posting. If you do, however, then what we just talked about, you are required to adhere to those requirements in terms of the pay range and the benefits. Let's say, for example, that you do not create a job posting, right? That it's something just more kind of word of mouth, which happens, right? And you don't have a job posting. In that situation, when you are interviewing the person, before you make, the law says that you should disclose to the applicant the pay scale and benefits to be offered for the position prior to any offer or discussion of compensation, right? So again, that's it's very fact specific, but in essence, it says if you don't have a job posting, right? Let's say it's word of mouth. When I come in for the interview, right, before we actually talk about money, you should, or at least this provision says you have to, tell me, hey, Scott, we are offering, for this position, the range that we're looking to pay someone is 40 to 50, right? And the law says you should have that discussion with me before I say, hey, what are you willing to pay for this? Now, so there's the other interesting thing about this, and again, I don't know who's on this per se in terms of where you have locations or the scope of the applicant pool that you're looking for. But keep in mind here, and this is very important, these pay transparency provisions, they don't apply just to positions that will be performed in Illinois, right? So let's say you are in Bloomington, but ultimately you are looking for, let's say, an IT position, right? And you're casting a wide net. Because at the end of the day, you say, hey, our IT person, may not be in Bloomington. If we get someone in Iowa or Wisconsin, that's okay, right? And so how the law looks at that in terms of, do you have to, for that job posting where you're looking and say, hey, we'll consider anybody. The question is, do we have to comply with the provisions if, for example, we know that, we're going to be looking outside of Illinois? And the question is, well, it depends. And how you determine that is one of two ways. One, you have to ask yourself, will the position, in terms of the work to be performed, be physically performed, at least in part, in Illinois, right? So I'll give you an example. My law firm is based in St. Louis. We have an office in right over the river. So we have attorneys kind of going back and forth all the time. And so in that situation, if we're looking for a lawyer, let's say in our St. Louis office, right, we would have to likely comply with the requirements, because that lawyer in St. Louis, it's a very good possibility, particularly if they're doing litigation, would have to cross over the river into Illinois to do legal work, right? Or, right, let's use the example of the IT person that we hire in Iowa, right, who's not going to ever have to come to Bloomington. The law says, all right, well, where is Scott's supervisor located? Is Scott's supervisor located in the Bloomington office? Okay, well, if that's the case, then that job description, right, that you're casting that wide net and say, hey, it could be outside of Illinois, it would need to comply with these requirements. So, long story short here, err on the side of caution, right? Because some of you may be casting a wider net outside of Illinois. So err on the side of caution. Again, it doesn't take that much effort, to kind of do what this law requires, is salary, wage, and the benefits. Very importantly as well, this, to the extent that the job posting may be if someone were successful internally, right? If that could be a promotion to them, then if you were to post that job externally, right? So you gave it to an outside recruiter. Within 14 days of you giving that job posting to the outside recruiter, you also have to post it internally. And the reason is because that job could be considered a promotion for someone internally. Now, some of you may be saying, and my clients have told me, hey, we know that we're not giving it to anybody internally, right? We know that. We don't have anybody qualified for it. But yes, it could be a promotion for Sally and Bob. But we know we're not giving it to them. Doesn't matter. Doesn't matter. The fact that this position for which you are posting, that you post an external posting, if Sally or Bob hypothetically were to apply, hypothetically were to get it via promotion, you have to also post it internally within 14 calendar days of you doing it internally. If you're using a third party, so a recruiter, make sure to provide that information to the recruiter. If the recruiter fails to include it in the job posting, that's on them. If you don't provide that information to the recruiter, and that's the reason why the recruiter doesn't provide and include that information in the job posting, well, then that's on you. That's on you. You'll be getting a copy of these slides. We won't go over this, but there are penalties for non-compliance. Okay. There will be amendments to an existing Illinois law here called the Illinois Human Rights Act. The Illinois Human Rights Act, for those that you don't know, is Illinois' version of Title VII, the Age Discrimination of Employment Act, the Americans with Disabilities Act, all the different federal employment-related laws. We've codified it here under one law called the Illinois Human Rights Act. Within the Human Rights Act, Illinois Human Rights Act, just like under Title VII, for example, there are things called protected categories, protected classifications. That's just a fancy legal word for you as an employer cannot make an employment decision because of my gender, my race, my sexual orientation, my age, my national origin. Those are protected categories. Well, the Illinois Human Rights Act has protected categories as well. And come January 1st, 2025, there will be 2 new protected categories under the Illinois Human Rights Act, which means you need to add these to your employee handbook under the EEO and harassment section. The first one, which has the potential to be a big pain in the ass, is called family responsibilities. And what this is family responsibilities means, and I've defined it for you here, is in a general sense, the personal care that one of your employees needs to provide to a family member. Now, personal care means very broadly defined to mean any personal care that we have to provide to a covered family member in order for them relating to basic medical, hygiene, nutritional, or safety needs. Or if, for example, elder mom or dad, right, needs to go to a physical therapy appointment, they can't drive anymore. Or it means if our employee says, hey, I have to be an emotional support person for my mom who is in, let's say, hospice, and I need to be there for her. That's personal care. The defined covered family member here. For those of you who are subject to the Family Medical Leave Act, you may see this and say, hey, this really looks eerily familiar. And you would be right. This definition of family responsibilities virtually mirrors a basis for eligibility for an employee being eligible to take leave under the Family Medical Leave Act, and that is for a serious health condition of a immediate family member. So I bring that up because if, for example, you are subject to FMLA, right, an employee is looking to take leave for family responsibilities, there is a high likelihood that that person is going to be eligible and for FMLA leave, right? And so you should look at it, analyze it under FMLA. That person's going to get it, likely, because it's FMLA. But for those of you not subject to FMLA, for those of you who, for example, are subject to FMLA, but the employee makes the request within the first year of employment, which means they're actually not eligible for FMLA, then you'd have to analyze it under here, I mean, the Illinois Human Rights Act, to determine whether or not you need to grant that request. So that's very important to understand that distinction, is that, you know, for those of you subject to FMLA, an employee who makes a request related to family responsibilities, you know, and is eligible for FMLA, they've been using for 1 year, 1,250 hours, utilize FMLA. That's where it's going to fall under. If you're not subject to FMLA, it's in the first year, then we're going to analyze it here. So what the law says is that we are not, or just because I tell you, hey, I need to take extended leave because I have to help, you know, take mom to the doctor, right, and take mom to physical therapy. And let's talk about an example where you are or are not subject to FMLA, but, or let's say you are, and it's the first year of employment, so that person's not eligible, right? Or you're not subject to FMLA. The question is, okay, do I have to grant that request, right? Maybe the employee says, you know, I know I'm supposed to start at 9 o'clock every day, but mom has got physical therapy at 9 o'clock on Monday, Wednesday, Friday. So I'm not going to be able to come in until 10:30, right? And your initial thought is, well, that's not going to work for us. So how do you handle that, right? Are you required to say, okay, fine, yes? And the answer is not necessarily. What the law says is that we as employers are not obligated to make any accommodations or modifications to existing workplace rules or policies. And that's the request, right? My request is telling you, hey, I'm not going to be able to come into work until 10:30 on Monday, Wednesdays, and Fridays. I'm asking you to make an accommodation for me. I'm also asking you, likely, to modify certain policies, right? Well, what policies? Well, look at your employee handbook. You should have a policy that says, hey, we expect you to be at your workstation or working when you're supposed to, right? If that's 9 o'clock, that's 9 o'clock. If you're not at your workstation at 9 o'clock, that means you're tardy. There's your attendance policy. There's your absenteeism policy, right? You likely all, if you're in Bloomington, you know, if you're in Bloomington or Peoria, you know, you're all subject to the Paid Leave for All Workers Act, right? And if you, for example, have a policy that says the employee is not eligible for paid leave until, after 90 days of employment. If I'm making that request on day 2, I'm asking you to make a modification to your paid leave policy, right? Because your policy says you're not eligible until 90 days and we don't advance time. Again, if your policy says that. So in those situations, you can say, Scott, no, right? Because you're asking us to make an accommodation. You're asking us to make a modification to the following policies. We're not going to do that. Now, should you, right? Sometimes there's a human element to this, right? Now, I can't tell you what to do in that scenario, but I'm telling you in terms of how you can analyze it. If, for example, you need to deny it, you need to make sure that you have policies in place, right, that could touch upon what the employee is asking of you, right? And it's always going to be scheduling, right? Attendance, absenteeism, timeliness, work performance, things like that. Okay. There's an amendment to another law, to the Illinois Human Rights Act that affects what's called in my world the statute of limitations. Statute of limitations is just a fancy legal word for how long does my employee have to sue me? That's what that means. And so right now, if I were to go to the Illinois Department of Human Rights and file a charge of discrimination between now and December 31st, I've got 300 days, right, from the date of the bad thing that happened to me to file a charge of discrimination against. Come January 1st, that 300 days now gets extended to 2 years. That, folks, in my opinion, is a game changer. That's not getting talked about enough. Because what that means is that our employees now have a much longer period of time to decide whether or not they're going to. In fact, I had a question to a client earlier today, kind of in your neck of the woods, asked me that question, said, how long do we have before this person, can't sue us anymore? Right. And I explained to them this very thing. And they're like, shit, 2 years? Yeah, 2 years. Now, that only means if they want to file a charge of discrimination with the Illinois Department of Human Rights. If they go to the EEOC, which is the federal equivalent to that, they only have 300 days. So just keep that in mind, right? Because ultimately they may below the 300-day statute of limitations and say, all right, we're just going to go to the Illinois Human Rights Act because we have a lot more time to do so, right? So again, you may think you're done with your problem, and lo and behold, 2 years later, it rears its ugly head again. So, keep that in mind in terms of if you ever ask, how long do we have to worry about? Well, for the Illinois Department of Human Rights, it's going to be 2 years come 1/1/25. Another protected class, a new protected category that's going to that come 1/1/25 that will be added to the Illinois Human Rights Act, just like the family responsibilities. Another one is reproductive health decisions. Name speaks for itself, so we won't spend a lot of time on that. Okay. There are amendments to a law here in Illinois called the law here is the existing law. It's called the Illinois Wage Payment and Collection Act. So it's been on the books for a long time, and there are amendments relating that are going to affect under that law that relate to, of all things, pay stubs. So come 1/1/25, the Illinois Wage Payment and Collection Act will now govern several things relating to pay stubs. One being what information is required to be included in our pay stubs that we give to employees. And that could be electronic pay stubs, or if you're doing old school and giving a hard copy. So as of 1/1/25, now hopefully much of this you already have on your pay stubs. I put something in bold here. You may not be doing one thing for the specific classification of employee, but come 1/1/25, all of your pay stubs must now include the following: The hours worked, right, for that pay period, the employee's rate of pay, any overtime pay, any overtime hours worked, gross wages earned, wage deductions, any deductions from wages, and total wages deductions year to date. Now you may be saying, who cares? We already are doing that. Okay, so why did I put in both hours worked? You likely or hopefully have been including all the hours worked for your hourly non-exempt, right? Those are folks who are subject to overtime because you need that in there, right? Because ultimately, if I work over 40 hours, then you've got to pay me time and a half. So the question I have for you, and if we were doing this in person, I'd say, show me, raise your hand if you are doing this. Are you also including hours worked for your salary exempt, right? Those that aren't eligible for overtime. Now, some of you are saying, why would we? Well, the reason is because in Illinois, there's about 5 laws, first of all, that require you to keep a daily time, to have daily time records for all of your employees, including salaried exempt, which means, right, you need to know how many hours your salaried exempt people worked on Monday, Tuesday, Wednesday, Thursday, and Friday. In fact, the law that all of you are subject to, the Paid Leave for All Workers Act, requires you to have time records. This law itself, the Illinois Wage Payment and Collection Act, requires you to have daily time records for salaried exempt employees, right? So my question to you, and this is rhetorical because I can't see any of you, are you including, first of all, are you keeping daily time records for all of your salaried exempt people? Hopefully all of you are nodding yes. If so, are you including those hours, the actual hours worked, not just, yes, Scott, we're putting 80 hours in it. Well, did I actually work 80 hours, right? If not, then why are you saying I worked 80 hours when I didn't, right? So no one understand that come 1/1, you need to put the hours worked for your salaried exempt, right? I assume, hopefully all of you are already doing that. You obviously are already doing that for your hourly non-exempt. All right, second amendment to the Wage Payment and Collection Act is we're going to be required to maintain copies of pay stubs for not less than 3 years after the date of payment, right? So hypothetically, right, let's say January 2nd is payday, right? You need to keep that pay stub for 3 years from January 2nd. So it's 3 years from the date of payment. You have to maintain copies of all your employees' pay stubs 3 years from the date of payment. To the extent that your one of your employees asks you from 1/1/25 for a copy of their pay stubs, no, if they're doing that, they're likely going to sue you. But if they're asking you for a copy of your pay stubs, or a former employee, and certainly if a former employee is asking you for that, they're going to sue you. We have 21 calendar days to provide them with a copy of their pay stubs, right? So let's say on January 3rd, right, I'm a former employee that you terminated on January 1st. And I think that you're misclassifying me as exempt. I should have been non-exempt. My pay stubs are very important because I'm going to use them to sue you. So I come to you and say, hey, I need my pay stubs, right? It's January 3rd. You'll have 21 calendar days from January 3rd to provide me with a copy of my pay stubs in the proceeding for the copy of my pay stubs since I've been employed there. Now, also, how are you going to give those to me? Well, I get to tell you, you don't get to tell me. So I may tell you, in fact, put them in a PDF and send them to my lawyer. And you will have to put them in a PDF and send them to my lawyer because I dictate to you how and where you send them. You unfortunately don't dictate me how and where you send them. An employee gets basically they can ask for their pay stubs twice in a 12-month calendar year. Same thing for a former employee. Now, for former employees, they have only up to 1 year from their date of separation to make that request. So let's say, for example, that you terminated me on December 1st, 2023. and on January 1st, 2025, I make that request. The response is too bad. You're too late, right? You had to make the request by December 1st, 2024. The request by the employee must be made to whoever in your entity is responsible for maintaining the payrolls, right? That could be your payroll department, resources, or they could actually even make it to their supervisor or department manager. So to the extent, we have to let our supervisors know this, right? Because let's say the employee makes the request to the supervisor and the supervisor does nothing with it. Well, that's not good. That's not good because we have 21 calendar days to respond, and there's penalties for non-compliance. The next amendment relates to if you provide electronic pay stubs, right? So let's say hypothetically that you use like an ADP, and people can log on to ADP and they can see their pay stubs. So if that is the case, right? So direct deposit, use electronic pay stubs, hypothetically, I just one example. The question is, if from my date of separation, is there a way, right, that I could log on to, let's say, my ADP account and get a copy of those pay stubs for at least 1 year after you terminate? If your answer is no, once we terminate you, your access to that ADP account cuts off, then listen up. Because what you'll need to do then is the following. Before you walk me out the door, you have to ask Scott, do you want us to provide you with a copy of your pay stubs going back 12 months from the date of separation? You got to record that in writing. You have to include the date on which that offer was made, and you have to indicate in there what I said in response. Now, again, to be clear, this only applies if you provide electronic pay stubs, as probably all of you do. And if I don't have access to them unilaterally, right, for at least 1 year after my employment. In other words, right, it can't be something we say, yeah, all you have to do is come and ask me. No, I have to be able to, for example, log onto my ADP account without asking you, right, and get a copy of it. If I can't do that, if I have to go to you to get them, then what I just talked about applies, right? Very important that you understand that. You get audited. Department of Labor is going to ask you, show us that you in fact made this offer to Scott, because he's telling us you did it. For everything I just talked about, for this offer, for the providing me pay stubs, and what you need to include on your pay stubs, don't do it. $500 per violation. All right. There's amendments to a law called the Illinois Personnel Record Review Act. What is the Illinois Personnel Record Review Act? That's the law where when we fire an employee and 2 days later the employee says, give me a copy of my personnel documents, that's the law that gives that right. So there are amendments that are made, being amendments that go into effect from 1/1/25. They relate to, and I'll talk about the first one, is how the employees have to structure their request. So this should go in your employee handbook, because come 1/1/25, we can actually deny an employee's request if they don't follow what the provisions state on the Personnel Record Review Act for how you're supposed to request it, right? So we deny it until they actually comply, right? So I'm not saying you say, hey, too bad, you had one shot, right? They'll actually just fix it and send you another email within 10 seconds. But you can state and you can require, as you can right now, any request needs to be in writing. Second, how they structure the request. You should include policy language that says any written request must include the following: the specific personnel records that you're requesting, or is it anything that they're entitled to? They need to tell us, are they requesting to physically inspect it? They want us to provide it, to make copies. They want us to send copies somewhere. Same thing with C, are they looking for hard copies or emailed copies? And they have to let us know who we should send them to or who is going to be inspecting it. For example, they may say, send them to my lawyer. Or my lawyer will, wants to review them, him or herself. Can't say no. Can't say no. Because the employee gets to designate that person. If the individual is requesting, for example, they have a comp file, and they say, hey, I need information from that comp file that you have, workers' comp I'm talking about. They will need to provide you with a signed medical release waiver that allows you to provide them with that information, particularly if that information is not going to them, but to, let's say, a union or, their attorney or someone else. So there are also amendments to the specific categories of personnel documents that we're going to be required to produce. So right now, until January 1st, the only things that we have to actually produce, and many employers, they kind of get lost in translation here. They think we got to give them everything. It's not the case. We're only required to actually give them any documents which have been used or we intend to use in determining my qualification for employment, a promotion that we, gave me, any transfer that may have been effectuated, any additional compensation you gave me, or any discharge if you terminated me, or if you took any disciplinary action against me. Generally, they're looking for employees, anything relating to a discharge or disciplinary action to see if there's anything with it. The new category of document, anything relating to benefits, right? So in terms of a qualification for employment, promotion, transfer, add benefits to that list now as well. Additionally, there are 3 new separate kind of broader categories of personnel documents that we have to also provide to employees. And they don't have to ask for this. Remember, the employee can say, I want anything that you have to which I am entitled to. So the 3 new categories are any types of employment-related contracts or agreements, right? A non-compete, a non-solicitation, an actual employment agreement. Any handbooks, right? Any handbooks that have been made available to the employee or that the employee acknowledged receiving, right? Full copies of handbooks. Or if you don't have a handbook, and let's say you have just kind of standalone policies, and you relied on one of those policies to discipline or terminate, then you have to provide me with a copy of that policy. Okay. Brand new law goes into effect January 1st, 2025. This brand new law is called the Freedom of Speech Act. It is a total misnomer. What is this Freedom of Speech Act? So, before we talk about what it is, let me tell you who was behind this particular legislation. It was our union friends. I say friends loosely because they are not your friends. The union wanted this, pushed it through Springfield, and ultimately they got what they wanted. So what is this? This particular law, it seeks to prevent us from basically giving our opinions on why employees shouldn't join or form a union if we are doing so in a mandatory meeting. So what do I mean by that? Let's say, for example, that you have, I have clients who every Monday, they have a mandatory Monday meeting. All the employees have to go to that meeting, right? Is to kind of see what's going on for that weekend. And during that meeting, mandatory meeting, everybody's got to be there. You say, hey, we learned that a union has been coming around talking to many of you. And we want to let you know why we think it's a bad idea for you to even consider forming a union, right? And when you say that, 5 people get up and walk out of the meeting. right? And you say, where the hell are you going? And they say, we don't want to hear it, nor do we have to. You say, well, if you don't come back, I'm going to discipline you or terminate. And they say, go ahead. And this is now January 15th. If you were to discipline or terminate them, you'll be in violation of this law. Violation of this law. So what we need to know is that you can still give your opinions about unions and why employees shouldn't join them, why they shouldn't form them. You can still do that. That is our right to do that. We always have that right. Unfortunately, with this new law, we cannot require employees to attend a meeting where we're going to share and communicate that. If the meeting is voluntary, right, it's okay. If the meeting is mandatory, you can still do it. But if somebody declines to attend that meeting, or if somebody gets up and walks out of that meeting, can't do anything about it. Can't do anything about it. In other words, you can't discipline them, can't terminate them, right? So, this new law, it's a misnomer, right? Because they define it as that employees need to be, it's designed to protect communications about political matters and religious matters, right? But we're not having mandatory meetings about political matters. But look how they've defined, they being the union, political matters. All of this, and then at the end they say, oh yeah, and by the way, a union. How is a union a political matter? It's not. But that's where they choose to add this in there. So again, important for you to understand in terms of what your rights are here. Still share your views on a union within the confines of the National Labor Relations Act. You can do so at a mandatory meeting or at a voluntary meeting. Just know that if it's mandatory and people get up, or if they know what you're going to talk about, and you say, hey, where is everybody? Right? And then, and then afterwards, the employees say, I didn't go because I knew you were going to share your opinion on a union and I didn't want to hear it. You cannot discipline them or take any other adverse action against them for getting up and walking out. It's a mandatory meeting, or declining to go to the mandatory meeting. If, again, your intent or agenda in the meeting is to communicate your opinion about a political matter, i.e. a union. Okay, amendments to the law here in Illinois called the Illinois Whistleblower Act. The Illinois Whistleblower Act is a law that says, hey, if an employee rats you out to somebody and you take action against them, you're in big trouble. That's retaliation. That's what the Whistleblower Act is in a nutshell. Now, there are several important amendments to this Illinois Whistleblower Act. The first one, in my opinion, very important, is how they are now going to define employer, effective 1/1/25. And why is that important? So the new definition of employer is the following. Any business, and then this is what they added, any person acting within the scope of his or her authority on behalf of the business in dealing with its employees. Well, that sure sounds like HR. That sure sounds like a supervisor, right? And I would venture to say that probably many of you here are maybe an HR or a supervisor. Well, listen up. And why is that important? It's important because, and I'll fast forward a little bit here, if an employee is able to prove that you retaliated against them or said something to them that caused them not to go to and complain, let's say to OSHA about you, they can prove that. They can prove that. So let's say, for example, Sally comes to you. Let's say you're a manufacturer. Sally comes to you and says, hey, I think there are, at least 5 safety violations that we're committing right now. And you say, well, Sally, thanks for letting us know. And Sally says, oh, just so you know, I'm going to call OSHA right now. And I'm gonna let them know. So, well, Sally, if you call OSHA, just know that today will be your last day. You will be fired, right? None of you should ever do that. Sally has always the right to, contact OSHA. But if you do, Sally can prove that because she recorded it. You're in big trouble. The big trouble, the new consequence and penalty is you could be subject to a criminal violation. You could be subject to a Class A misdemeanor now. You have criminal liability in addition to civil penalties, right? Now, Sally, of course, would have to be able to establish this. But again, look how employer is defined, right? It's your company and you individually, right? So you need to be very careful, right? If you're the one in communication. Now, who could this consequence, who could this affect most? Our supervisors. Let's say we have a rogue supervisor who tells Sally, don't even think about doing, don't even think about it. You're not going to know that, right? You're not going to know what your supervisor said until you get a lawsuit. So our supervisors need to be aware of what the consequences are as relates to them and us as an employer. So, in terms of what our employees could complain, right? It could be that they say, hey, I'm going to disclose this to the state of Illinois, to OSHA, to the National Labor Relations Board, to the EEOC, or they say, I have disclosed this to OSHA, to the state of Illinois, to Relations Board, to the EEOC. And you say, all right, well, now you're fired, or we're disciplined, right? Or if you say, if you do so, know that we're going to fire you. Now the person feels, okay, well, I can't lose my job, so I can't. Any one of those is a violation of this act. Any one of those could subject you or your employer to civil damages, and you, if you're involved in that, to criminal liability as well. All right, I've got about 11 minutes left here. For those of you that use E-Verify, there are amendments to the law in which the E-Verify provisions are located. So there's a law here in Illinois called the Illinois Right to Privacy in the Workplace Act. The provisions relating to E-Verify, for some reason, are under this law called the Illinois Right to Privacy in the Workplace Act. There are amendments being made that relating to use of E-Verify. Now, let me, there's been a lot of confusion and questions saying, hey, we use E-Verify. Do these amendments state that we can't use E-Verify anymore? Or we're thinking about using E-Verify. Can we no longer use E-Verify? The answer to both of those questions is this law has absolutely nothing to do with your ability to use E-Verify. Let me repeat that. This law has absolutely nothing to do with your ability to continue using E-Verify, or if you want to use E-Verify in the future. The Illinois Department of Labor does not have a jurisdiction and cannot tell you can or can't use E-Verify. That's a federal thing. That is a federal thing. So let me just say that out front because I know I've been getting that question a lot. What the amendments relate to, this could be something that happens now quite a bit based on the election, the presidential election. So, President-elect Trump is one of his biggest things is immigration. These E-Verify amendments relate just to that. What do I mean by that? So let's say you use E-Verify, and I'm a new applicant, and you submit my information, that I provide you through the E-Verify process, and you get a response back that says, no match, which means the name or the social security number I provided to you that you used to E-Verify doesn't match Social Security Administration's records. So that's scenario number one. And these amendments dictate now how you handle and address that situation. In other words, they dictate what documents or information, once you get that response back, you're required now to provide the employee. How much time you're required to provide the employee to see if they can correct the issue. Why I don't like this, and just notice who is behind all this, are good friends at the union who don't care about us, who don't think outside the box and the implications that this has for us, right? There's a federal law called the Immigration Reform and Control Act, right? That's I-9. Why am I bringing that up? Because you may encounter a situation where you get the result back from E-Verify and it says no match or whatever it says. And you approach it and you say, hey, Scott, we got this response back. It appears to be saying Social Security number you gave us doesn't match what SSA has on file. Do you know why? Right? Do you know why? And I come clean. I said, yeah, because I gave you a false Social Security number. It's not mine. Well, the Immigration Reform and Control Act says you've got to terminate me immediately. Not at the end of the day, not a week from now, that very minute. Because now you have actual knowledge that I'm not authorized to work in the US. Why I don't like this is that these provisions don't encounter that situation. Right? They don't encounter that. They don't even address it. Right? So you may have that situation. And now you may be asking yourself, what do I do? Right? What do I do? I mean, ultimately, right, it's if you've got actual knowledge, right? And by actual knowledge, I mean the person tells you, I gave a fake Social Security number, then rely on what the federal law says. Federal law says you need to terminate Scott immediately and document that conversation. Because when you terminate me, right, that employee, potentially, former employee, may file a claim against you and say you violated the new provisions under E-Verify because you didn't follow the procedure. And your response is, why the hell would I? You admitted to me that you weren't authorized because you told me it was fake Social Security number. And if you haven't documented that conversation, then it's a he said, she said, right? Now you've got a 50-50 chance. 50-50 chance. So, you've got to be careful about that. Now, the other thing to keep in mind here too, and I bring up President-elect Trump, because for those of you who may have, if you remember during his first presidency, I shouldn't say many of you, but maybe some of you were getting what's called no match letters in the mail, right? It was Social Security Administration saying, hey, we, for the W-2s that you submitted to us, they don't match the Social Security numbers, don't match the name or Social Security number we have on file for that person. I anticipate that we will see an uptick of that again. When President Biden took office, basically got rid of that. No one was getting a no match letter. Maybe IRS did, if you had a Form 1095-C, but Social Security Administration basically stopped sending them out for all intents and purposes. Based on what we know President-elect Trump to be item agenda number 1, know that I anticipate that, we may start seeing a lot of these. So if you're in an industry, hospitality, manufacturing, that, you have a target on your back based on who you employ, make sure you're doing what you need to at the outset with I-9s, because ultimately you may get one of those no matches. And why am I bringing this up? Because the amendments to the E-Verify, even though it has nothing to do with E-Verify, the unions included this in here. They said, hey, if you get a no match letter, this is what you have to do. Even if it has nothing to do with E-Verify, right? This is, so your employees already. You've been your employees for a year. So these provisions are very important for you if you get a no match letter, right? Or if you use E-Verify and you got, what I'll call a no match as well. Now, I want to understand that there are procedures in place, not procedures, but requirements and provisions that you need to follow should either of those situations apply. Again, does not address the scenario where the employee comes clean and says, I gave you a fake social security number. So, my recommendation for any of you is reach out to competent employment counsel should you find yourself in that position. There's a right way to handle it and the wrong way. Okay. Last slide here. So just as an FYI, I'm sure hopefully all of you know this already, but if you recall back in May, the U.S. Department of Labor issued a new rule that would have increased the salary threshold for exempt employees to keep them exempt. And it's 35,568. The new rule increased it basically two stages. Said on July 1st, if someone is not making 43,888, you got to increase them to 43,888. And if on January 1st, 2025, they're not making 58,656, you got to increase them to 58,656. This is assuming, of course, that they're properly classified in the first place. Well, fortunately, back in November, in the great state of Texas, where all the awful employment rules and laws go to die, a judge set that entire rule aside. What does that mean for you? It means that come January 1st, 2025, you do not have to increase anyone's salary to 58, when I say anyone's, salary to exempt employee salary, 58,656, if they don't meet that. Right now, some of you may have already increased people to 43,888 on July 1st because you needed to. The right way to handle that too, in terms of if you wanna say, just kidding. Again, that's something you need to speak with competent employment counsel, because if you do it wrong, if you do it incorrectly, you can be in big trouble. Know that just the other day, the U.S. Department of Labor appealed this. I don't know why they even wasted their time, because once Trump takes office, the new Trump Department of Labor is just likely going to say, yeah, we're going to withdraw that appeal. So, it's likely going to go nowhere. Last but not least, I'm not going to go through these, but I did reference it earlier. For those of you who, and it's not just manufacturers, but really applies to manufacturers who use temporary laborers that you're getting from a staffing company. And hopefully you already know this already, that it's not, oh, I had no idea. In August of 2024, there were amendments made to this law called the Day and Temporary Labor Service Act that include your use of temporary laborers that you get from staffing companies. Again, I won't go through that. We've got a copy of the slides. Hopefully you all know about that. So that's all I have. It is 1 o'clock. I don't know if there's any questions, but I'm happy to spend at least 10 more minutes to try to answer any if there are any in the chat box.
Hi, Scott. This is Diane Cote. Thank you so much for all this information. So helpful. I did have a question about exempt employees. If they're working from home and working on the weekends, I'm assuming those are hours to be included in the tracking that you were speaking of.
Any time that I work needs to be tracked. Correct. So the law requires, there's several of them. The Illinois Wage Payment and Collection Act, which is where that pay stubs law, the amendments comes from. The Illinois minimum wage law requires this. All of you, just based on where you're located, you're all subject to the Paid Leave for All Workers Act. It requires us to have a daily time record. And what that means is how many hours did Scott work on Monday? How many hours did Scott work on Tuesday? Just like our hourly non-exempt, right? Some employers say we just default to 80. Is that okay? My response is no, not. Because I may not have worked 80 hours. And why does that matter? Right? It matters because if you are misclassified, right? Now you are saying, and what I'm going to say is, I told my employer that I didn't work 80 hours. but I worked 85. And they told me, too bad, they're going to automatically put 80 hours. Why does that matter? Of course, because one, you're misclassifying me, and two, you owe me 5 hours of overtime. They can go back 3 years, right? Not right, they can. So I don't recommend you just, put in 80 hours, which a lot of companies do, and I think they're playing with fire, candidly. My recommendation is always comply with the law. And if your salaried exempt people don't like it, too bad, because there are penalties for non-compliance. So I think that answers your question.
Yeah, that's helpful. Thanks. I mean, I'm just thinking of myself. I take calls at night from people all the time. I don't log any of that stuff. So I take calls at night. I take calls on the weekend, answer emails. So good info. Thank you.
Feel free to unmute yourself if you do. You don't have to, I think they can unmute yourself, right?
Yeah, I think I saw somebody had dropped this one in, and I was curious on the answer as well about how does this hourly thing apply with any employees we have that might be commission only or on a draw system?
So, that's a very fact-specific question. And generally I say, how are you classifying them now, right? And there's only two answers. One, we're classifying them as hourly non-exempt, or we're classifying them as salaried exempt. And I will caution you, if you're classifying your salespeople, assuming their sales and commission, as salaried exempt, that may not be the case. So in terms of how to answer your question, I don't know how you're classifying them now. Tell me, well, salaried exempt, I may tell you, they may not be candidate. They may not be. So, many companies think, well, they're salaried, their sales, they're salaried exempt. That is just not true. I can tell you, because companies get sued all the time from guess who? Salespeople who say you misclassified me, right? Because they know you don't have time records from them, and they know that, hey, or they're going to say, I work 60 hours a week. And they know you can't refute that, because why? You don't have time records to refute it. So that question, how does it apply to them, is, again, regardless of how you have them classified, they need to, because it's only two things, salary exempt or hourly non-exempt. This still applies. They're not going to fight it, but listen, they're not going to pay the penalty either, right? You are.
Right. Thank you.
I had asked in the chat, I know you gave some qualifications that are required on pay stubs. And one of the things that was missing from that list is PTO or well-being sick time. Do those have to be included on a pay stub?
I forget what the Paid Leave for All Workers Act states on that. So ultimately, and you're all subject to the Paid Leave for All Workers Act, so I would refer you to that. That will, and I forget, it's just been a while. I forget what the Paid Leave for All Workers Act requires. In terms of, you have to include it on a pay stub. I don't know the answer to it, but I would go to Department of Labor has FAQs on the Paid Leave for All Workers Act. I would refer to that. Because this again is just Illinois Wage Payment Collection Act separate from Paid Leave for All Workers Act, right? So there's multiple different laws. And if a specific law says, hey, you have to include that on a pay stub, like the Paid Leave for All Workers Act says that, and you have to. Doesn't matter. You can't say, well, even though Department of Labor is the same agency enforcing these, right? Ultimately, each law requires, whatever that law requires, that's what you have to go by.
Scott, this is Terry. I have a question. If there is a salary exempt personnel and they have to work on call, They already work, like, let's say 40 hours a week, and then it's part of their job description, part of their responsibilities to rotate for on-call. Is on-call then those hours that they work, and let's say they may end up getting in a situation that takes an hour or 2 hours, is that going to be considered then something for overtime?
So, if they are truly salaried exempt, right? Which means you're paying them the proper salary threshold and, right, their job duties fit into the executive, administrative, or professional category, then they're never eligible for overtime, right? Like me, and probably you, right? We are never eligible for overtime. Doesn't matter how many hours we work. I can work 80 hours in a week. Still gonna get paid the same salary every week. Probably the same for you. If, right, to your question, if you are misclassified and you're misclassifying me as salaried exempt, but really I'm not hourly non-exempt, then yeah, those hours are gonna matter because you should be paying me overtime. So, that's why this is so important. That's why, I always say, hey, make sure you have those time records. Because I will tell you that the employee, they always do this. When you get sued, and don't be naive enough to think you're not going to get sued, because you will. They will inevitably say, because they always do, we work 60 hours a week. You're going to say, no way in hell did you do. And they're going to say, prove me wrong. And the only way you can prove me wrong is if you have timesheets. So in your example, that person, right, who works their normal week and then works on call hours, if you, again, hypothetically are misclassifying them and those extra hours are overtime and you don't have time records from that person to establish how many hours they work each week, if you get sued, you will have absolutely no way to refute what they tell you they work. Because courts say, we don't care what you say, employer. You should have time records. You know better. So if you don't have time records, and if Scott says he works 60 hours a week, Scott works 60 hours a week. That is why these time records are so important, because they really are only defense we have when you get sued for a wage and hour violation, and likely it'll be a class action lawsuit, right? Plaintiff's attorneys, when I reach out to them and I go, your guy didn't work this, they always say, well, sure, send me the pay record, send me time records, because they know I don't have it, right? So, that is why time records are so important. Now, for those folks who are truly exempt, right? The president of your organization, probably many of you, does it matter, right? No, because we're never eligible for overtime. Is the Illinois Department of Labor going to come to you and say, hey, saw your time record here, said you worked 80 hours for 2 years? They don't care. Why don't they care? Right? Because you're never eligible for overtime. So who cares? Now, with that being said, I'm not advocating lying or just, doing a default of 80. But what I'm saying is, for those workers who are on the line, in terms of whether or not they're truly exempt or not, you better have time records for them, because if they sue you and it happens, there's an adverse finding against you that you're misclassifying them, that is your only defense of that case.
Thank you.
Okay. All right. Well,
It looks like, real quick, Scott, that there were some questions on the chat version. We had Isabella Marino ask, does the hold for the whistleblower law, does that hold both parties accountable? The supervisor could be held individually liable, and the organization also be held responsible for the actions of its employee.
if they sue individually, yes. So it could be company A and Scott Cruz as named defendants. So yes. Now, whether or not they choose the name, ultimately, listen, they know you're not gonna be able to afford anything. So it's they may not sue a person individually, right? Because ultimately the employer is going to deep pockets. But to answer your question, yeah, I've seen that scenario where they've named the employer and, you know, the rogue supervisor or the rogue HR person. Anything else? Okay. Here's my contact info. I will preface it this way. If there's a question you have about something I said, right? Hey, you know, like for example, the question that the individual asked, you know, the Wage Payment Collection Act, the pay stubs, I didn't see anything about PTO, right? You know, that's not specific to your company. If you're asking me, hey, this is what we have going on, well, that you know, you need to establish a relationship with our firm, because that's attorney-client, you know, that's that type of advice, right? But if it's a, hey, what you had on this slide, what does that mean, right? That's, I can say, I can email back and say, this is what I mean. But if it's asking, this is what we have going on, well, that's not the same, right? So I preface it that way with that. So with that being said, happy holidays, and you know, compliance is the name of the game. This is why, you know, the chamber puts this on. This is why I put this on for many chambers, many companies, right? Because ultimately, you know, you have to know in order to comply, right? You can't comply if you don't know. So take it to heart. Make sure you advise anybody else in your organization on these things as well. It's great that you know it, but you know, there's probably others where these laws are implicated too. All right. Thanks, everybody.
Thank you. And remember, everything is was recorded, and so this will be posted on the McLean County Chamber of Commerce YouTube as well as our website, so anyone can look back at this at a later date. Thank you all for attending, and happy holidays.